A unanimous Supreme Court decision just dropped. 9 justices, 0 dissents. And if you carry a firearm in your vehicle, this ruling changes the rules of every single traffic stop you will ever have from this point forward. Here is the part that should stop you cold right now. Most gun owners will not hear about this for months. Some will not hear about it at all, and a small number will find out the hard way, standing on the shoulder of a road watching their vehicle get torn apart because a completely legal firearm just turned a broken taillight stop into the worst night of their lives. They will find out too late. After the search, after the charges, after they are sitting across a table from a public defender trying to reconstruct a roadside conversation they did not know mattered. That is not going to be you, not after today. But stay with me, because this is not a simple story. There are layers here that most people covering this ruling will never bother to explain. There are things this decision protects absolutely, and there are things it does not touch at all. There are moments in a traffic stop where your knowledge of this ruling will protect you completely, and there are moments where one wrong word, one wrong movement, one wrong assumption will make it entirely useless, no matter how unanimous it was. Knowing half the picture is sometimes more dangerous than knowing nothing at all. Before we go any further, make sure you are subscribed. Rulings like this one get covered the moment they drop, not 3 weeks later when the nuance has already been stripped away. Hit that button now while you still have time to understand this before you ever need to use it. Now let us get into it. To understand why this ruling is as significant as it is, you have to understand the problem that made it necessary. The United States Constitution does not contradict itself. At least, it was never designed to. But for years, 2 of its most fundamental protections were being quietly weaponized against each other, and the people paying the price were the ones doing everything right. The Second Amendment gives you the right to keep and bear arms, settled, foundational, exercised responsibly by tens of millions of Americans every single day. They go through background checks, they complete training courses, they carry legally, they are not criminals, they are citizens exercising a constitutional right. The Fourth Amendment gives you the right to be free from unreasonable searches and seizures. No government agent, no law enforcement officer, no official of any kind can search your vehicle without either a valid warrant or a specific legal justification called probable cause. It is one of the foundational guarantees of a free society, the wall between individual privacy and unchecked government authority. 2 rights, both constitutionally protected, both real. And for years, they were colliding silently in traffic stops from California to Florida, and the collision was going almost entirely in one direction. Here is exactly where they were crashing. When a police officer approaches your vehicle and discovers during the interaction that you have a firearm inside, a very specific legal question immediately arises. What does that knowledge authorize him to do next? Does the mere fact that a gun is present, a legal gun, a properly permitted gun, a gun you have every constitutional right to possess, does that fact alone give the officer justification to search your entire vehicle without a warrant and without any other reason? In the lower courts, a dangerous doctrine had been forming. It was called the moment of threat rule, and it was spreading through the 2nd, 4th, 5th, and 8th circuits. Under this rule, if a situation turned tense or an officer used force, the courts would only look at the precise final seconds where the threat occurred. They put on chronological blinders. They did not care what happened 5 minutes before. They did not ask whether the officer's own behavior escalated a peaceful stop into a dangerous one. The logic worked like this. Firearms are inherently dangerous. Dangerous objects create unsafe situations. Unsafe situations justify officer intervention. Therefore, the presence of a firearm in a vehicle gives law enforcement an automatic basis to treat the entire encounter as a high-threat scenario. Follow that logic to its conclusion, and you arrive at something that should alarm every gun owner in this country. If carrying a legal firearm automatically generates probable cause, then exercising your Second Amendment right automatically destroys your Fourth Amendment right. You cannot have both at the same time. You have to choose. Carry legally and surrender your privacy, or keep your privacy and leave the firearm at home. Pick one. That is not what the Constitution says. That has never been what the Constitution means, but it was happening in real cases, affecting real people, and it was spreading, until it landed in the case of Barnes versus Felix before the highest court in the land. Cases like this do not begin in marble courtrooms with 9 justices in black robes. They begin exactly where yours would, on the side of a road. A driver named Ashtian Barnes was pulled over for a minor civil violation, unpaid tolls, not reckless driving, not a DUI, the kind of stop that in a normal world lasts 6 minutes and ends with a fine small enough to forget about by next week. During that stop, a firearm became part of the picture. In the final seconds of the encounter, the officer jumped onto the moving vehicle and fired. When the case went to court, the lower courts applied the moment of threat doctrine. They said we only care about those final 2 seconds. In those 2 seconds, the officer felt he was in danger because of the car and the gun. Therefore, everything he did was legal. They ignored the toll violation that started the stop. They ignored the minutes of interaction that preceded the violence. They effectively said that the presence of a firearm creates a safety exception broad enough to override the entire Fourth Amendment analysis. Then the case reached the Supreme Court of the United States, and what happened in that chamber is something that does not happen by accident. 9 justices, representing every ideological perspective on that bench, from the most conservative members to the most liberal, looked at the moment of threat rule and arrived at the exact same conclusion. It is unconstitutional. Justice Elena Kagan, writing for a unified court, was unambiguous. You cannot examine a traffic stop through a keyhole. You cannot ignore the totality of the circumstances. You cannot put on chronological blinders that conveniently erase everything that happened before the moment an officer chose to use force, 9-0. When the Supreme Court agrees 9-0 on anything touching firearms and law enforcement authority, you stop everything and pay attention, because that level of unanimity does not emerge from a close call. It does not come from a judgment call that reasonable legal minds could make differently. It comes from a constitutional violation so clear, so fundamental, so plainly wrong, that 9 very different people looked at it from 9 different angles and all saw the same thing. Here is the core of what the court ruled. Read every single word. The mere presence of a legally possessed firearm in a vehicle does not, by itself, constitute justification to ignore your constitutional protections. The court told law enforcement agencies across the country directly and without ambiguity, you cannot use a citizen's exercise of one constitutional right as the justification to strip them of another. Armed does not mean criminal. Law-abiding gun owners are not suspects, and the government may not treat them as such. 9-0. Now, here is where I have to slow you down completely, because I know exactly what some of you are thinking right now. You are thinking this ruling is a wall, a legal force field, that the next time an officer approaches your window and you have a firearm in the vehicle, you have a 9-0 Supreme Court decision sitting in your back pocket. And that is the end of the conversation. It is not the end of the conversation. If you treat it like it is, this ruling will not protect you. The totality of the circumstances standard is a double-edged sword. While it prevents an officer from focusing only on the final 2 seconds of a stop, it also allows everything you do from the moment those lights hit your rearview mirror to become part of the legal picture. The court did not just expand your protections, it expanded the entire battlefield, and on that battlefield there are specific trapdoors that can swallow your rights whole. Trapdoor 1 is the distinction between possession and manner. The Supreme Court was clear that having a legal gun does not make you a criminal, but this ruling does not protect you if the manner in which you have that gun violates a specific state statute. This is where the most responsible, well-intentioned, genuinely law-abiding gun owners get caught off guard, and it is entirely preventable with preparation. Most states have specific statutes governing how a firearm must be stored or transported in a vehicle. Some require the firearm to be unloaded. Some require a locked container. Some prohibit a loaded firearm anywhere within reach of the driver. States like Maryland and New Jersey, for example, have strict storage requirements that apply even to permit holders from other states. These laws vary significantly from state to state, and within states, from permit holders to non-permit holders. If an officer approaches your window and observes a firearm stored in direct violation of a state storage statute, the 9-0 ruling will not help you. In that moment, the officer is not citing the presence of a firearm as his basis for a search. He is citing a specific, observable, articulable violation of a specific state law. That is real probable cause, and it has nothing to do with the constitutional question the Supreme Court just answered. The gun stops being a constitutional right and starts being evidence of a crime. Law enforcement is already being trained to look for these technical storage violations as a way to reopen the Fourth Amendment window that the Supreme Court just tried to close. Know exactly how your state requires you to store a firearm in a vehicle before you put the car in drive. Not approximately, not based on what you heard at the range. Exactly. Check the statute itself. Because getting this wrong does not just cost you the protection of this ruling, it potentially costs you the firearm, and depending on the state, it can cost you significantly more than that. Trapdoor 2 is consent, and this is the most dangerous trap, because it is the only one that relies entirely on your own permission. The moment you say yes, the Fourth Amendment evaporates completely. In the wake of this 9-0 decision, officers are being trained in what are called reasonable officer psychological tactics. They know they cannot simply search your vehicle because they saw a firearm, so they will try to get you to hand them a blank check voluntarily. It will not sound like a legal maneuver. It will sound like a reasonable request from someone who is just doing their job. It sounds like this. For my safety and yours, while I run your license, do you mind if I just take a quick look to make sure everything is in order? Or, you seem like a reasonable person, let us just get this done and I can get you on your way. Every instinct you have as a law-abiding citizen who has nothing to hide tells you to say yes, to be cooperative, to show him you are not a problem. That instinct will cost you everything in this moment. The second you say yes, the Barnes versus Felix protections are gone. It does not matter anymore. You have handed him a blank check. Voluntary consent is full legal authorization to search your vehicle, your bags, your glove box, your trunk, everything. If he finds anything, you cannot walk into a courtroom later and cite the 9-0 ruling. You waived it. An attorney cannot suppress evidence found in a consensual search by arguing that the officer lacked probable cause. You eliminated the need for probable cause the moment you cooperated. Consent overrides the court every single time. Trapdoor 3 is what happens when the gun becomes part of a larger picture. The court ruled that a legal firearm by itself does not create probable cause. The critical phrase is by itself. The moment anything else enters the stop, the legal analysis shifts entirely, and this is the trapdoor that law enforcement will use most aggressively in the post-ruling world. Officers adapt. If the gun alone no longer justifies a search, then the approach becomes building a picture where the gun is one element among several, where no single factor is the stated reason, but the combination creates the probable cause that the firearm alone no longer provides. A strong odor in the vehicle, a passenger behaving in a way that raises genuine concern, an answer about your destination that differs slightly from an answer you gave 2 minutes earlier, something visible in plain view. In that situation, the officer is not going to say the gun is the reason for the search. He is going to say the gun plus the other factors combined created a reasonable perception of danger. Your nervousness early in the stop. A hand that moved toward the glove box before he asked you to. 3 seconds where your hands were not visible. Under the totality standard, all of it counts. This is why your behavior from the very first second matters. You need to give them nothing else to work with, nothing voluntary, nothing accidental, nothing born of nerves or the very human instinct to fill silence with words. Now let us talk about exactly what you do from the moment those lights appear in your rearview mirror. Because knowledge without execution is completely useless. Pull over promptly and safely. Do not slow down gradually while you figure out what to do. Find a safe place on the right shoulder, signal your intention clearly, and stop. Turn off the engine. Roll down the driver's side window completely. If your vehicle has tinted rear windows, roll those down too. Give the approaching officer a clear visual line into the interior before he reaches your door. If it is nighttime or low visibility, turn on your interior dome light, then place both hands flat on top of the steering wheel and leave them there. Do not reach for your registration. Do not reach for your insurance card. Do not move toward the glove box. Do not reach toward the center console. Sit still, hands visible, and give the officer nothing ambiguous to respond to before he even reaches your window. A significant number of traffic stop escalations have nothing to do with legal arguments. They happen because an officer approaching a vehicle sees movement he cannot identify and makes a split-second decision under uncertainty. Remove that uncertainty before it can become a problem. When the officer arrives at your window, this is where the golden script begins. These are the sentences that protect your life on the road and preserve your legal position in court. The first sentence is your status declaration. Keep your hands at 10 and 2 on the wheel and say clearly and calmly, "Officer, I want to let you know, for your safety and mine, that I am legally carrying a firearm. How would you like me to proceed?" That sentence accomplishes everything at once. It demonstrates complete transparency and cooperation. It removes the element of surprise, which is the variable most likely to turn a routine stop into something dangerous. It also puts the burden of directing the next physical movement on the officer, which is exactly where a non-threatening citizen wants that burden to be. You are not concealing anything. You are not challenging anything. You are showing him exactly who you are and inviting him to direct the interaction. Most officers respond to that sentence exactly the way you want them to, because it is the sentence of someone who has nothing to hide and is not trying to create a problem. The second sentence is your location clarification. If he asks where the firearm is, do not point at it and do not touch it. Say, "It is located in my right hip holster or the center console or wherever it actually is. My registration is in the glove box. Which would you like me to reach for first?" You are narrating your actions before they happen. On a body camera, this establishes that you were being objectively reasonable and methodical, which makes it nearly impossible for an officer to later claim in court that you made a furtive or threatening movement. Know your state's disclosure laws before any of this matters. Some states have a legal duty to inform requirement, meaning you must disclose that you are carrying the moment you are stopped, before the officer even asks. Other states carry no such legal obligation. Know which category your state falls into before you ever put a firearm in your car. If your state requires disclosure, give it immediately and exactly as the law requires. If your state does not require it and the firearm is not visible, you are under no legal obligation to volunteer the information. But if you are asked directly whether there is a firearm in the vehicle, the answer is always the truth. Always. A single lie to a law enforcement officer in that context can transform a completely routine stop into a criminal event faster than almost anything else that could happen at that window. The cover-up is almost always worse than the thing being covered. Then comes the moment that determines everything. The officer says, "Do you mind if I take a look inside your vehicle?" This is the third sentence of your golden script, and it is the one most people fail. You respond calmly, without raising your voice, without sarcasm, without any hostility in your tone or your body language. "Officer, I respect the work you do, but I do not consent to any searches of my person or my vehicle." That is the sentence. That is all of it. You are not citing case names. You are not reciting constitutional amendments by number. You are not delivering a legal lecture on the shoulder of a highway to a man holding a Glock and wearing a vest. None of that helps you. All of it makes you look like someone trying to win an argument. And the side of the road is not where arguments get won. Courtrooms are where arguments get won. Every word you say is being recorded on a body camera. If you argue, the officer records your hostility and non-compliance as part of the totality of circumstances that made him concerned for his safety. Your job at that window is to protect your legal position so that an attorney can do the winning later. If the officer responds with the line that has been used at traffic stops for decades, "If you have nothing to hide, why not let me look?" You recognize it for exactly what it is: psychological pressure, a tactic designed to make refusal feel like proof of guilt. It is not a legal argument, and it is not a right the officer possesses. You respond, "I am exercising my Fourth Amendment rights. I do not consent to a search." Then comes the fourth sentence, the silence tool. After you refuse consent, the officer will apply pressure. He will ask why you are being difficult. He may ask where you are coming from, where you are headed, whether there is anything in the vehicle he should know about. You say, "I am exercising my constitutional rights and I prefer not to answer any further questions without an attorney." That is the Fifth Amendment shield. It stops you from accidentally constructing the building blocks of probable cause out of nervous habit. Every additional explanation you offer is another statement that can be used. Every clarification introduces a potential inconsistency. Every volunteered detail is information that did not have to exist. Silence is not suspicious. Silence is not guilt. Silence is a legal right. And in this specific moment, it is one of the most powerful tools available to you. Use it. If the officer proceeds with a search after you have clearly refused consent and there is no legitimate justification that meets the new standard, do not physically resist under any circumstances. This is the fifth and final sentence. "I am not resisting, but I do not consent to this search." Say it clearly and in a calm, audible voice, loud enough for the body camera to capture every word. Then let the officer's actions create the legal record. Every step taken after an unlawful escalation is now subject to scrutiny in court. Every item discovered in a search that should not have occurred is potentially suppressible under the exclusionary rule. Your composure in that moment is not weakness and it is not surrender. It is the foundation of the legal case your attorney will build. Every word you say, every movement you make, every reaction you have after that refusal either helps your case or damages it. Choose every one of them deliberately. The moment the stop ends and you are back on the road, document everything immediately. The time and exact location of the stop. The officer's name and badge number if you observed them. The precise sequence of events. Every question asked and every answer given. Whether you consented or refused. What justification the officer provided for any search that occurred. Write it down or voice memo it before you have driven 5 miles from that location. Memory degrades faster than people expect, especially memory formed under stress. Specific details are what attorneys use to win suppression hearings, not general recollections. There is one more scenario worth understanding before you feel fully prepared. Justice Kavanaugh, in his concurring opinion joined by 3 other justices, reminded the country that traffic stops are extraordinarily dangerous for law enforcement. When a situation is unpredictable, the risks multiply on both sides. If you are stopped late at night on a rural road with no witnesses and low visibility, the officer's reasonable perception of threat is at its highest point. This is where the 9-0 ruling is most vulnerable to being bypassed in practice. If your firearm is in the same compartment as your registration and you reach toward it without narrating what you are doing, you are building a totality of circumstances that the officer can use to justify escalation. Low visibility, a late hour, an unannounced movement toward a weapon, and the unpredictability of the situation combine into exactly the kind of picture that courts give officers the most deference on. This is precisely why the golden script matters most in those conditions. In daylight with witnesses, your calm behavior speaks for itself. In the middle of the night on an empty road, your words are the only thing establishing the record that will matter later. Narrate every action before you take it. Keep your hands visible longer than feels necessary. There is also one final layer that almost nobody covering this ruling will mention, but it could expose you without warning if you ever travel across state lines with a firearm. This ruling strengthens your constitutional protections nationally, but it does not create a uniform firearm law across all 50 states. Every state retains its own laws governing concealed carry, open carry, permit requirements, reciprocity agreements, storage regulations, duty to inform obligations, and magazine restrictions. The moment you cross a state line, every one of those variables potentially changes. A carry permit valid in your home state may be completely unrecognized in the next state. A firearm stored exactly as your home state requires may be stored in direct violation of the laws of the state you just entered. And if an officer observes your firearm stored in violation of their storage statute, you are not protected by this ruling. He has specific, articulable, probable cause that has nothing to do with the constitutional question the Supreme Court just answered. If you carry and you travel, researching the laws of every state you pass through is not optional. It is the minimum preparation required to ensure that this ruling's protection actually applies to you at every mile. Use a reputable firearm law resource or travel application. Check State Department of Public Safety websites directly. Understand exactly where your permit is recognized and where it is not before you arrive, not after. Here is what the Supreme Court actually said to this country with a 9-0 vote. The armed citizen and the criminal suspect are not the same person. Certain corners of law enforcement had been operating as though they were equivalent, as though choosing to exercise a constitutional right was itself evidence of suspicious intent, as though the responsible gun owner who went through background checks and training and permitting was entitled to less privacy than someone who had never picked up a firearm. The court said no. 9 voices, no exceptions. You do not have to choose between your rights. You do not have to surrender one to keep the other. But rights on paper are not automatic protection in real-world encounters. This ruling only functions as a shield if the roadside encounter was handled correctly from the first moment those lights appeared. It only reaches a courtroom in a form an attorney can use if you did not hand the officer a weapon against you by consenting, by lying, by making unexplained movements, or by talking yourself into probable cause out of nervous habit. Most people who carry a firearm will never see a breakdown like this one. They will continue driving with a weapon they have every right to carry, completely unaware of what just changed and completely unprepared for the one specific moment when that change matters most. They will learn about their rights after the stop went sideways, after the search happened, after the document they needed to protect themselves was already signed away in the form of verbal consent on the shoulder of a highway. You are not that person. You put in the time before something went wrong. You know what this ruling actually says, not just the headline. You know the trapdoors. You know the golden script. You know what to say and what not to say and exactly when to stop talking entirely. The next time those lights flash in your rearview mirror, you will not be guessing. You will not be improvising. You will know exactly what the court said, exactly where its protection begins, and exactly what you need to do to make sure it reaches you when you need it most. Stay informed, stay calm, stay lawful. Because in this country, rights are most powerful in the hands of people who understand precisely how to use them.